Hi, everybody. Thank you for attending today's webinar. I appreciate your attendance and taking the time out of your busy days to come and have a listen to the presentation for this week. This week, I'm presenting on the corporate practice of medicine, which is a very unique and interesting area of law that comes up in a rather particular field. And I've had some experience in litigating this particular issue. It is a complicated area that has, until recently, sat rather dormant for quite a long period of time. But recent case law over the last few decades has revived it and shown that the corporate practice of medicine is very much alive and very impactful on different people who want to be a part of a business that engages in the practice of medicine or want to associate in some way with someone who is engaged in the practice of medicine. So as it is a fairly complicated area of law, I'm going to be just giving a bit of a primer on some of the issues that develop and some of the statutes and case law that are out there, but this is by no means an exhaustive review of the corporate practice of medicine, or CPOM, as I often call it for short. Many people call it for short. So with no further ado, I'll dive right into it. So perhaps we can start with something that seems very basic and fundamental, but is actually defined by statute, which is the practice of medicine itself. And RCW 1871-011 actually defines the practice of medicine, and it includes offering or undertaking to diagnose, cure, advise, or prescribe for any human disease, ailment, injury, infirmity, deformity, pain, or other condition, physical or mental, real or imaginary, by any means or instrumentality. So pretty broad, quite frankly. Administers or prescribes drugs or medicinal preparations, severs or penetrates the tissues of human beings, or essentially a form of advertisement, uses on cards, books, papers, signs, or other written or printed means of giving information to the public in the conduct of any occupation or profession pertaining to the diagnosis or treatment of human disease or conditions. The designation, doctor of medicine, physician, surgeon, MD, or some combination like that, essentially, unless it's a designation contains a description that it's a branch of the healing arts for which someone has a license. But essentially, any of these things constitutes the practice of medicine, and it is a fairly broad arena in which, people who are engaged in, medicinal work and that kind of thing will get some sued under this statute and the definition of the practice of medicine. So better safe than sorry. It's important to take a look at the statute and make sure, if you don't know already, but in all honesty, it is pretty broad. And so most people who are practicing in the medical field in one form or another get covered under this. There are some carve-outs, but for the most part, it's a pretty broad statute. So what is the corporate practice of medicine doctrine? Fundamentally, there isn't an express statute that actually just defines it. It's a long-standing doctrine in Washington State. It's been around for a very long period of time. And essentially, it prohibits the practice of medicine by corporate entities. Well, that seems pretty basic to the actual name of the doctrine, the corporate practice of medicine doctrine. And the idea behind that is that only individuals can undergo the examination and the training and the screening that is required to obtain a professional license. And Washington State requires a professional license for the practice of medicine. It prohibits the unlicensed practice of medicine. And in reality, that makes a whole host of sense. Most people don't want to go see a physician who hasn't gone to medical school and received their license. And people don't typically go see a dentist who is not a licensed dentist. And for that reason, there's, this law has been put into place that people who practice medicine have to have a license. Obviously, it's a really important area that all of us rely upon, the expertise of these individuals. So again, have to be licensed. And the doctrine really developed out of a number of different concerns, essentially about commercial exploitation of the practice of medicine. Most significantly, some kind of division of loyalty that there might be between the corporation and the patient, and the concerns over lay people controlling medical decision-making. So really a push and pull between what's best for the patient in a medical practitioner's expertise and opinion versus what might be most profitable for the corporate entity that is involved in the practice of medicine. And so as a blanket, the courts as a blanket kind of fundamental level prohibit the corporate practice of medicine. And that's kind of it. You have to be licensed to practice medicine. And so if you're licensed, you can practice medicine, but if you're not licensed, you can't be involved in the practice of medicine. Now, of course, there have been carve-outs and nuances to that I'm going to get into, but that's kind of the fundamental level. And not every state actually has this doctrine, though many of them do. But also many of the ones that do, the doctrine has remained dormant for a long time. And in Washington state, it was dormant for decades until it came up again. And now the kind of specter of the corporate practice of medicine is still out there and something very much to consider when engaging in business dealings involving medicine. So who can practice medicine? Generally speaking, as I alluded to before, only licensed individuals can practice medicine, and there's actually a statute on that, RCW 1871-021, which says no person may practice or represent himself or herself as practicing medicine without first having a valid license to do so. Pretty basic, pretty fundamental, more or less what I was talking about earlier, and the considerations that all of us essentially take for granted, that we want people engaging in this incredibly important practice to actually have a license to do so, to show that they're qualified. Now, there are some carve-outs. Carve-out number one are professional corporations. So this is under the RCW 18.100 statute. There's a couple of subsections there, but essentially the 010 statute, and I'll paraphrase it, it's written here on the slide, but essentially it allows a group of individuals to render the same professional service to the public for which those individuals are required to be licensed or have some other legal authorization to engage in that professional service. So oftentimes you'll see professional corporations that consist of accountants or lawyers or something similar to that, and that carve-out also exists for the practice of medicine. Subsection 050 states that people who are duly licensed or otherwise legally authorized to render the same professional services can indeed organize and become the shareholders of a professional corporation for profit under the Business Corporations Act for purposes of rendering that professional service. And one or more of them will be the incorporators of that professional corporation. So the statute provides, again, that these professionals in a particular industry can form a professional corporation together. And that's been extended to also be professional limited liability companies as well. And a lot of professional entities will be PLLCs. And you're seeing that more and more lately. Law firms often do it for limited liability purposes that you would often see people do LLCs as opposed to corporations in other contexts. But nonetheless, it is possible for medical professionals to organize in this fashion with other medical professionals to form a professional services entity of some sort. Now, interestingly, the statute doesn't actually specify that a professional services corporation can practice medicine, but Washington courts have interpreted that way. There's a citation there to the Columbia Physical Therapy case, but essentially the courts have acknowledged that this is a carve-out. And the carve-out is for professional corporations, but for all intents and purposes, professional limited liability companies would be safe as well under this kind of organization. And then the other carve-out, of course, are health maintenance organizations, or HMOs, which I'm not going to go into detail on today because that is its own large area of regulatory and legal frameworks and issues that need to be navigated through to understand. But essentially, an HMO can also engage in the practice of medicine so long as you follow all the rules that are required to do that. So having discussed who can practice medicine, should talk about the arrangements that get people into trouble. The corporate practice of medicine is strict, indeed. And it can arise in a number of contexts where someone who is not practicing medicine can run into trouble, even though that person is not engaged in the actual, what a layman's person would consider the practice of medicine. For example, employing a medical professional, that can be a problem. There has been cases where a corporation violated the corporate practice of medicine by employing an optometrist, even though the optometrist was exercising professional judgment conscientiously in each individual case. That did not matter. It didn't matter because that person was employed by the corporation, and the corporation, which was not, again, this is not a professional services corporation where everybody was a licensed physician of some kind. People who were not licensed to engage in the practice of medicine had decision-making authority over the corporation, over the profits, over the way the business would be organized, and any number of things which could affect the physician's practice. So even if this optometrist in this case was exercising professional judgment conscientiously in each individual case, as they say, and really doing that person's job properly, the issue was still the specter of that person's professional services being compromised by someone who didn't practice medicine. And that's really the fundamental issue behind the corporate practice of medicine, is not allowing people who are not engaged in the practice of medicine to call the shots in one form or another. So another example was a partnership was found to violate the corporate practice of medicine after selling its Seattle office to a licensed dentist, because as part of the deal, the partnership, which didn't practice medicine, was going to handle advertising, handle the accounts, and purchase supplies for the dentist. So the dentist is still doing the dental work. But again, because there was this outside entity that was not licensed to practice medicine, not made up of people who were organized properly that all practice medicine, they were still having some amount of control over, again, accounts, advertising, supplying the dentist, that could influence the dentist to act in one way or another way due to reasons outside of that dentist's professional judgment in the industry. Another circumstance, simply going into business with a medical professional. This is a fascinating case, the Morelli versus Essan case, which came up back in 1988 and kind of signaled one of the resurgent cases of the corporate practice of medicine. This was a general partnership where one partner had a medical license and the other did not. And generally speaking, the medical professional was the one handling the medicine, and the person who was not a medical professional was just running the business side of things, as they call it. But because both partners could profit from and essentially control the clinic, was not good enough. It didn't matter that the individual with the medical license was the only one actually practicing medicine. It was the possibility that someone who was not practicing medicine could engage in conduct and make decisions that would influence the partnership, and essentially allow a non-practitioner to have authority in an area where it's the provision of medical services. So that was also a no-no. And it's even gone so far as essentially just profiting from a medical professional's business. Fascinating case, the Falazadeh versus Orbanian case, where a non-medical professional landlord, so totally separate now from the tenant, violated the corporate practice of medicine because the lease provisions entitled the landlord to a percentage of his medical professional tenant's profits. Now, in this case, it wasn't found per se illegal. The court really had concern about the level of profit, which was something like 50%. And also the control being exercised. There was a certain measure of control that the landlord was still exercising over the tenant in order to ensure profits. And there's kind of complicated details there and in that case that basically made the court concerned and found that there was a violation of the CPOM. Now, does that mean that there's not a circumstance where a landlord could profit share with the tenant, where the landlord's not practicing medicine, but the tenant is? I suppose it's possible. I haven't seen that case law, but I can say that it would be the kind of thing that you would want reviewed very, very carefully, because there is an easy chance of running afoul of the corporate practice of medicine. Because again, when someone who's not involved and not licensed is taking a direct profit from medical practitioners' practice, the ability of the non-medical professional to meddle in how that business is being run, even if it's not directly, even if it's indirectly or not, these are not circumstances where people are necessarily being nefarious or trying to do anything wrong or anything like that. They may not even realize that they are violating corporate practice of medicine. They may not consider themselves practicing medicine in any real meaningful sense. Nonetheless, that concern is out there and the courts take it very seriously. And so if someone is engaging in anything related to the practice of medicine and is not a medical practitioner, is not licensed, they should be considering the corporate practice of medicine very carefully before entering into that kind of arrangement, because again, it's a pretty strict statute. So what can happen if you violate the corporate practice of medicine? We've talked a lot about all the various ways that it can be violated, and indeed that these violations can happen even if someone doesn't know that they're violating it. And I have seen firsthand circumstances where people with the best intentions, circumstances where people are really just trying to do good and they're not directly involved, and they're essentially parties that are really wearing the hero cap, can get in a bad situation because of the broadness of the statute. So what can happen? I suppose the major thing is what's covered in the Morelli case, which is leave the parties in the positions where the court finds them, even if they acted in good faith. Well, what does that mean? The answer is it's complicated and not entirely clear, but essentially in that case, there was a lawsuit for accounting where they were going to account for the profits and all of that of the partnership. And essentially the court said, this arrangement is illegal. We're going to leave the parties where we found them. And there is no right to an accounting, no right to an accounting of the profits and distribution accordingly. And the case kind of leaves it at that in the conversation, but the implications are dangerous for people who are already in or who are in a business arrangement like this, because it can essentially say your business arrangement is illegal and the rights that you think you have under this business arrangement, you don't have. And as far as who can continue to practice, well, if you're not licensed, it's probably not going to be you that's going to get to continue to practice, running the clinic or whatever it is, that's the actual business. It's going to be the medical professional. So the party who is engaged in this business transaction can be the one left out at the end of the day. And that can be a pretty dangerous thing. Now, there's something I'm not going to get too into, I'm not really going to get into today, called imperi delicto, which is where the less culpable party may be able to maintain an action on the illegal contract, which is kind of a funny way to put it. But essentially, the contract is deemed illegal, but there are some extra contractual rights that a less culpable party may be able to maintain if they're found to be not as at fault for what happened. But where both parties are innocent or equally culpable, it's a pretty harsh remedy that the courts can and have applied. Beyond that, there are some other violation penalties, if you will. There can be a civil fine, under RCW 18-130-190 sub 3, which is up to $1,000 per day. So pretty steep. And then section 7A and B under the same statute actually show that there are criminal penalties that can be imposed. Gross misdemeanor for the first violation and a Class C felony for subsequent violations. And then, of course, injunctions can be had as well to essentially stop the parties from engaging in this business. So violation of the corporate practice of medicine is very serious. And there are serious consequences that go beyond just a court action where one party can essentially use it as a sword against the other one by essentially saying, hey, this is illegal and I'm the one with the license, so you don't really get to be a part of this anymore. It can go beyond that court action to actual fines and even criminal liability. So again, really important to be careful if you are in a business that's involved in any way with medicine and you don't have a license yourself, or if you're thinking about getting involved, this is something that is very important to consider and look into and really talk to legal counsel about in order to navigate so that you are not violating the corporate practice of medicine. So what can you do? the first line item there says form a PSC or a PLLC. So really if you are a medical practitioner, if you're licensed and you want to enter into a business and run a clinic with other licensed people, best bet is to form a professional services corporation, form a professional limited liability company, follow the statutory requirements doing that, get it right, and do it on the front end, because those organizations are pretty much, at least under the case law and extrapolations from the case law, pretty safe ways to run this kind of business so long as you follow the rules. Even forming an LLC or a corporation where everybody is actually a licensed medical practitioner, the case law is not entirely clear on that. And frankly, I have not seen that case come up. It's possible that it's come up recently in other states, but in any case, even that could be a landmine. Now, you know, whether or not a court is going to find that there's a violation of the CPOM because it's not a professional services corporation or limited liability company, again, is unclear. But if you're forming an entity with other medical practitioners, I would say best bet is to actually go through the process of forming a professional services corporation or professional limited liability companies. Just don't have to worry about that sort of thing. And the second thing you can do is, of course, what I said a little bit earlier, which is just be very careful. If you are in any way planning to open a clinic, be part of a company that has a clinic, go into business with people who are involved in medicine. You know, if you're a landlord who's going to rent to a tenant that is, a professional limited liability company engaged in the practice of medicine, and you want to, deal with profit sharing or any of these kinds of circumstances, even if they don't on their face seem like they could violate the CPOM, I would dot your I's and cross your T's and do your due diligence to make sure that you're in the clear, mainly because the consequences can be pretty bad and pretty adverse. And honestly, good people, innocent people who aren't trying to break the law or trying to do wrong can find themselves swept up in this because they just didn't cover the details or understand the nuances of that. So be careful is my parting shot there. Other than that, if you have any questions or want to have a conversation about this issue or want more details or find yourself in a circumstance where you can use some assistance navigating through concerns relating to the corporate practice of medicine, my contact information is there on the slide. You can call my office, you can send an email. I'd be happy to set up a time to talk to you and go through it. And so I hope you enjoyed today's presentation. I know it's a lot that was covered. There's a lot of issues there, and the time frame we have and just the circumstances that we do webinars, we can't always dive into all the details and the nitty-gritty of it. And there's a lot there, but I hope it gives you a little bit of a primer into the corporate practice of medicine, at least enough to know that if you're involved and you're concerned, maybe I ought to call someone and talk through this and just make sure that I'm doing things the right way. Better safe than sorry, I would say. So would love to hear from you. If you have any questions or concerns, please feel free to contact me. Thank you for coming and attending today's webinar. I hope you enjoyed it, and I wish you a very best rest of your week and weekend. Thank you so much.